Attached to this video, along with all the other exhibits, will be my, I love my checklist, a debt buyer lawsuit defense checklist that will allow you to initially review your lawsuit, look at the key documentation they have or don't have, and also the checklist will give you a response strategy so you can put forward your best efforts in your counter affidavit, your answer, your motion to dismiss, and your counterclaim. There's no contract, no assignee. You just find one thing wrong and the whole thing collapses. They had nothing there, and we took everything they said and used everything we could against them. So, hey, Brian Parker coming at you with another exciting video. The last video I did was a breakdown of a creditor lawsuit that was against FNBO. Not one I go against a lot, maybe once a year, but it was a breakdown of how to handle creditor lawsuits in general. And you always hear me say use their documents against them. We introduced how we use their words against them. So today we'll have a debt buyer lawsuit, one of the most filed lawsuits in the nation. Portfolio Recovery Associates. They're right up there with Midland and Jeff Cap. They're the top 3 filers right now in the nation. This one is about breaking down the PRA lawsuit, their documents to support them, and the words they use to go against you. And again, as I made the point in the FNBO lawsuit video, they had nothing there, and we took everything they said and used everything we could against them. So at the end of the lawsuit, at the end of the video, we had everything going our way, and I've since filed a motion to dismiss. And we'll see how that turns out. This is one where attached to this video, you'll have my counter affidavit in Word for the specific lawsuit that I answered for my client, a counter affidavit mentioning this $24 million consent judgment that was found against PRA in 2023. I'll put 2 answers attached to the video for you to use. And I'll also have a template counterclaim that incorporates the $24 million consent order you can use for more powerful ammo against them. And of course, my show notes, which I sit down and write like a madman. Here is the lawsuit that my client faced, Shazam, and that is a basic PRA lawsuit, one size fits all states, and it is really not much there, but I wanted always to show you the affidavit. You see the wherefore clause, and that shows how much the person owes and why the court should find against the debtor. So what we do is we look at their documents, but we first look at their words. So let's take a look at their words. So let's look at paragraph 2 and 3. So you can see defendant at their request was granted an extension of credit from the Bank of Missouri, all right? And issued to defendant as the Bank of Missouri credit account ending in the account number, thereafter the account. Plaintiff is the successor in interest to Ally Bank. Where did Ally Bank come from? Why are they saying that? So you key on that. That'll end up in your counter affidavit. So they mention the Bank of Missouri contract, but they don't attach the cardholder agreement. Again, there must be a signed cardholder agreement if it's a breach of contract case showing why you owe this specific debt under the terms and condition. It states that Ally Bank is a successor in interest, but has no real proof of how Ally Bank obtained any interest. So we look at the reference to any exhibit. So we've looked at the words. Remember, we're always looking for the linchpin. The linchpin is if we pull the linchpin away, the whole thing falls down. You know I've done videos on linchpin. There's a couple there. Go check them out. So we look at paragraph 4, Shazam. Defendant is now justly indebted to plaintiff over and above all legal counterclaims in the amount of whatever. See attached documents which evidence plaintiff's assignment and the account due owing on the account. The account due and owing on the account, Exhibit A. So they set this up to say, hey court, you can believe us because we've got documents attached. Now we get into the use their documents phase against them. So here is their first document. Document A. A is for affidavit, and that's their affidavit by a China Hudson. First thing you do, as a matter of course, when you get an affidavit, you immediately go Google or do whatever search you use, the affiant, and even maybe the person that's notarizing the document. Because you wouldn't believe how many times I find that's the wrong signature or a changed signature or there's something weird going on. You just find one thing wrong and the whole thing collapses. So let's take a look at the same thing that we do. We now have a document, but we're going to check out their words in that document. So let's look at paragraph 2 and 3. And it says, she's reviewed and has stored a review of the business records of the original creditor, the Bank of Missouri, and those records transferred to account assignee. PRA is considered the account assignee, and Ally Bank, the account seller. So for Ally Bank to sell anything to anybody, they must have an assignment or something from Missouri Bank to Ally Bank showing and then on top of that, the specific debt of yours, or in my case, my clients, transferring in between with all these assignments. That doesn't exist, even though she says she's looked at all the records. So paragraph 2 states an assignment occurred with no proof, and it refers to the Bank of Missouri as the original creditor and Ally Bank as the account seller, and PRA is the account assignee, as we said, but there's no contract, no assignee. They also say that the accounts are now owned by the account assignee as of 11/25/24, remember that date. According to the same affidavit, the debtor in this case owed money to the account assignee, who is Ally Bank, as of 10/23/2024. So I'm not sure if that's when the assignment occurred. Neither is PRA or their custodian of records that signed a sworn affidavit, because she's mentioned nothing about that and there's no contract attached. For her to say, I have reviewed the business records, she must have reviewed all the assignments and the contract to show that my client owes something at a certain time. Remember what I said about the original contract, okay, as we get into this? According to the records at number 4, she says, everything was transferred to the account assignee, which is PRA, and the account seller, and maintained in the ordinary course of business. That's just 8036 language. But we look at the bill of sale that they say this whole thing emanates from, that's attached as Exhibit A. And there, actually the bill of sale they attached wasn't even, well, it is kind of a bill of sale, but it, to me, appears to be fragments. So I'll give you the 3 fragments they had, Shazam. And that's saying bill of sale, November 25th, 2024, this occurred with a forward flow agreement. No forward flow agreement is attached. Were this case to go on, that's the first thing you ask for in discovery, because the whole bill of sale says subject to the terms and the conditions of the certain forward flow purchase agreement. So the whole thing is subject to the terms. So there's no court in the land that's going to say you can't have that, because the bill of sale rests upon the terms and conditions of a very relevant document. So if this thing, that's your plan B in your pocket, keep it in your pocket, it's your chip. If they start giving you a fight, first discovery request is, I want to see the forward flow agreement. They never want you to see that. They're incorporating actually entities that are contracted with them that are not part of the lawsuit. And it probably says in their agreement that the assignor says, hey, PRA or whomever, you take this without recourse. We don't want this anymore. So they don't want to talk about that. So go for that. That's a dagger in the throat. So, So Exhibit A1, the bill of sale, that's what the purchase accounts are described as in the bill of sale as A1. That says these purchase accounts were sold and assigned, transferred, delivered, and conveyed from Ally Bank. Remember, nobody's given anything to Ally Bank, to Portfolio Recovery Associates as described in the bill of sale dated 12/3/2024. That's a hint and a half for you that something's amiss here. So did it occur on November 25th, as their affidavit said, or is it 12/3/24 as their own bill of sale says? But in no way made it to the sworn affidavit that the Miss China Hudson had signed off as saying, yep, I've looked at everything. Did she look at her own documents? So, and lastly, in conclusion, that last part, that everybody's signing off on December 3rd. So that's when a sale of any kind occurs. You can put any dates you want into an agreement, but until something is signed on the line that is dotted, nothing has happened. But that doesn't make it to the affidavit that supposedly is sworn under oath. So the bill of sale refers to an Exhibit A1 that states the accounts were transferred in December. There's no electronic file that they claim is attached to the lawsuit. It isn't. And again, no proof of how Ally obtained the accounts. So what does all this mean, and what did I mention and emphasize for you? The contract. In March of 2023, the CFPB, a government agency that overlooks all credit, mortgage, debt collector situations, FDCPA, they make all these rules. That organization is now toothless. It's just been gutted. It's underfunded and all its powers have been taken away. I won't get into why or the politics of that, but back then that meant something. Now, so oftentimes people call me or ask me, they say, hey, shall I file something with the Attorney General of my state or with the CFPB or the FTC? And I go, that is not gonna help you. They can't, they've been underfunding. The current administration has an emphasis on business right now, and that may work out. It may work out for America, and the money hopefully flows down to the consumer. And it looks as a consumer regulatory watchdog, as a regulation or a police it's a hindrance to business we have to trust business, is what the administration says. So it's gutted all these organizations that they claim hurt business. But March 23, 2023, when the CFPB, the Consumer Financial Protection Bureau, had a lot of guts, a lot of strength and power behind it. Let me put this up there. The CFPB orders repeat offender portfolio recovery associates to pay more than $24 million for continued illegal debt collection practices and consumer reporting violations. So that stands today, okay? So what good is it? Well, to a court, seeing something like that is good. It shows that someone complained and repeatedly they violated something, PRA. And so when someone says to me, should I report to the FTC? Should I go to CFPB? Yeah, go do that. Don't expect results. And if anything happens, great. But what happens is the businesses still respond to those complaints saying, we didn't do nothing. But it is paperwork, it is a paper trail of you, a consumer, a debtor, showing, look, this is wrong, this is illegal. It's good in a legal setting. So the order, Shazam, prohibits portfolio recovery associates from collecting debts unless it has access to certain documents that meet its obligation to have reasonable basis to believe it is collecting debts that the consumers actually owe. So that's why you break down the lawsuit and the affidavit. They have to rely on the same documents that you have to rely upon to see if you owe the debt to a debt buyer. And so what really this order did, and I'll show you, the order not only made them pay, it made them do this. It said, Shazam, you have to produce the original count level documentation, or OALD. That means any documentation that a creditor or the creditor's agent, such as a servicer, provided to a consumer about a debt or complete transactional history of a debt created by a creditor or that creditor's agent, such as a servicer, or a copy of a judgment awarded to a creditor, awarded to a PA in a lawsuit, PRA, on or after March 9, 2016. One of the things that requires PRA to do when it files a lawsuit, and I will quote it, it's got to show creditor level paperwork, original account level documentation, like the original contract that you signed. They must file that with the lawsuit. There's The consent order gives them an enormous amount of things that they have to attach to the lawsuit. What they did is they started creating, after this, PRA started creating this massive amounts of data forms. It's a common thing in the industry. If you're required to do something, but you kind of don't have what you need to do for that requirement, the industry will throw a ton of documents. Like, for example, if you seek validation on a debt, they'll send back a huge paper file with the belief that you just paper someone to death. It's actually a move that attorneys do to other attorneys that want to hide something. You ask for something and they, what's called papering you to death. They give you so much, they assume that you're not going to spend the time reading it, and if you do, it's laborious task. So here, the CFPB says you got to give us everything, and they're specific about it, and it's got to be account level documentation or the original contract, and here clearly there is no contract here. So they violated that order, and you can use that against them. So you can't go to CFPB now and go, hey, could you do something about this, the order? But you can use it in a court setting. The courts will honor this. So what I've done is I've incorporated in a counter affidavit for you. I've also done and attached to this video a counterclaim. So let me just give you the first page of the counterclaim, Shazam, to show you what I mean. So you can see there, again, you know how I write things. We have to always be closing, tip off the court to what's this about. The counterclaim violations of the CFPB v. PRA consent order of 2023. You can do that in your answer too. You can put the answer to complaint showing violation of the CFPB versus PRA consent order of 2023. Now you have my attention. Somebody violate, you're already supporting your case. So this is what's on my second page. Remember, I always front load answers, counterclaims, motion, exactly what's going on. Shazam, I put right in the counterclaim, CFP orders, repeated offender, portfolio recovery, blah, blah, blah. And then you can see a long list of things that they did to violate this order. We'll go to the next page, which starts threatening with consumers with potential legal actions and initiating debt collection lawsuits without offering or possessing required documentation, that account level document. So, and then you'll see my preliminary statement, and I put right in there, requiring defendant PRA, the consent order, to provide complete credit level documentation when suing consumers. Defendant is suing Miss Debbie debtor here with no contract between debtor and, in this case, Barclays, and no assignment of the debtor debt between the creditor and defendant attached to the lawsuit. So that's my counterclaim that I will file against PRA. I just wanted to show you how that's done. In fact, the last page there, inside the counterclaim, you can see they're required to give the original count level documentation, the OALD. So that is how you take on a debt by a lawsuit. Yesterday we did a creditor lawsuit attached to this video at Killdebt.com and incorporated in ParkerGPT. So if you've got this monstrous task, got to file an answer, I've got all this, I don't have much time, ParkerGPT does it in minutes. Just check your state law and the facts just before you sign up. It'll tell you how to file it, how to do a proof of service, what court to go to. We are up in our game with Killdebt. We're going to be adding a 10K link. So instead of searching the internet to find out what was securitized or where, we're going to put it right in the Killdebt.com website. And we, of course, are always updating ParkerGPT to do all the work for you. So attached to this video will be the counter affidavit in Word I used for this lawsuit, a counter affidavit mentioning the $24 million consent order. So I used a counter affidavit, and then I added, hey, court, from you, I've reviewed this consent order and they're violating that. 2 answers, I'll give you 2 answers in Word for the price of 1. A template counterclaim. So here, a counterclaim, you're inside a case and you file a counterclaim. So that's inside the case. If you're filing a standalone case on its own, hey, the debt collector did this, I'm going to file a federal action, or even in same case in state court, but separate from the case you're currently involved in. A counterclaim inside a case can be easily converted to your case against a debt collector. It goes from a counterclaim to your claim. So that's a nice thing to have in your work against debt collectors that are suing you, that are breaking the law and violating consent orders. By the way, a consent order is exactly that. It's a consent by both parties that they will follow the rules of the order. So PRA can't come back and go, well, you know, the current administration doesn't like the CFPB. They signed, they paid. And by the way, they signed and they paid after violating the same sort of order a couple of years ago. That's why it was 24 million. It was only 12 million last time. So even in this political environment that goes against regulatory agencies, this was a consent order. The same as when you have a payment plan on a debt you've discounted and now owe to the debt collector as a settlement. You sign a consent order. So that's what PRA did. You have to follow the rules, or there's a default mechanism where PRA is really in trouble. So use their documents and their words and their consent orders against them. I hope this helps. You can apply it to any debt buyer as far as the framework and skeleton of attacking these cases. And I would look up, the CFPB has a number of these actions against debt buyers, large debt buyers like PRA. Good luck. I hope this helps.